Welcome to EUPrivacyForAll, Session 21 on GDPR, Transfers based on adequacy decisions, Article 41. Negotiations regarding adequacy were quite long, and we've got lots of remarks to share. So let's jump into Article 41, key provisions. Basically, European Parliament laid down the fact that adequacy is decided by EU Commission regarding transfers taking place with a third country or a territory or a processing sector within that third country or the international organization in question. The added value is that transfers framed by adequacy decision shall not require any further specific authorization from DPAs. Criteria to take into account are rule of law relevant legislation, including on national security, as proposed by European Parliament, jurisprudential precedents, EU data subjects effective administrative and judicial redress, independent supervisory authorities, including sufficient sanctioning powers in the country or organization to which data are transferred should be checked. Also, international commitments. On EU Council side, provisions were almost the same, with few additions though. Regarding the criteria, and the first one most of all, it includes rules for onward transfer of personal data to another third country or international organization. Following up on the negotiations regarding Article 41, let's notice that EU Commission delegated acts could be taken on revocations as proposed by European Parliament. The Commission shall also, on an ongoing basis, monitor developments in third countries and international organizations. EU Commission shall be empowered to adopt delegated acts. EDPB, the new Working Party 29, shall give the Commission an opinion prior to the adoption of delegated acts on adequacy. Finally, it was proposed that publication of the list of adequate countries should be provided both in official journal of the European Union and on its website. Finally, European Parliament suggested that existing decisions of adequacy remain into force 5 years. On its side, EU Council took most of the proposals. However, it suggested that the Commission monitor the functioning of decisions not referring to delegated acts. This way, it could repeal, amend, or suspend decisions taken without retroactive effect. Also, the Commission shall enter into consultations with a third country or international organization with a view to remedying the situation. Finally, Article 41, entitled Transfers with an Adequacy Decision, lays down the following. A transfer of personal data to a third country or an international organization may take place where the Commission has decided that the third country or a territory or one or more specified sectors within that third country or the international organization in question ensures an adequate level of protection. Such transfer shall not require any specific authorization. When assessing the adequacy, Article 41(2) provides 3 criteria. The first, A, is the rule of law, the human rights and fundamental freedoms, relevant legislation, including, as suggested by European Parliament, public security, defense, national security and criminal law, and the access of public authorities to personal data, but also the implementation of this legislation, rules for onward transfer, as suggested by EU Council, jurisprudential precedents, effective and enforceable data subjects' rights, and finally, effective administrative and judicial redress for the data subjects. The second criterion on the existence and effective functioning of one or more independent supervisory authorities is dedicated to ensure that enforcement will be provided and that adequate sanctioning powers are also possible to implement in the country or organization to which data will be disclosed. The third criterion is based on international commitments or other obligations arising from legally binding conventions. The Commission may decide that some country, territory, or organization ensure an adequate level of protection. However, this decision shall be submitted to a mechanism for periodic review, at least every 4 years. Finally, the Commission, on an ongoing basis, shall monitor developments, and those developments will affect the decision adopted based on the new regulation, but also decisions adopted on the basis of Article 25(6) of the current directive. Finally, it is laid down in paragraph 5 that the Commission shall decide when a country or an international organization no longer ensures an adequate level of protection, and to the extent necessary, repeal, amend, or suspend the decision of adequacy, however, without retroactive effect. The Commission shall also enter into consultations in view of remedying the situation. Whenever no adequacy is recognized, it is without prejudice to transfers held pursuant to appropriate safeguards or binding corporate rules or in the frame of negotiations. Publication in the official journal of the European Union or on its website is also framed. It shall include a list of countries and organizations that do provide or do not provide anymore an adequate level of protection. A key recital in GDPR is recital 81. It basically stresses whatever is already laid down in Article 41. Two inputs to take from recital 41b first, that is to say that the assessment of adequacy done by EU Commission shall take into account all relevant developments, and second, from Article 66(1) CE, the European Data Protection Board, the new Working Party 29, shall, on its own initiative or at the request of the EU Commission, give the Commission an opinion for the assessment of the adequacy of the level of protection in a third country or international organization. What's in the directive currently? So basically, on the principle, adequate level of protection is the key condition to transfer data. This adequacy shall be assessed in the light of all circumstances surrounding a data transfer operation or set of data transfer operations. That is to say, paying attention to the nature of the data, the purpose, duration of the proposed processing, country of origin and country of final destination, rules of law, professional rules and security measures. The Member States and the Commission shall inform each other when they do find that a country, and it is only a country-based assessment, does not ensure an adequate level of protection. When the Commission decides that no adequacy can be recognized, Member States shall take the measures necessary. The Commission shall enter into negotiations with a view to remedying the situation. Finally, Member States shall take the measures necessary to comply with the Commission's decision overall. In such a complex and controversial topic, what should accountable data controllers and processors retain and get prepared for. First, being ready to anticipate a substantial change in the assessment of adequacy of data transfers, notably due to the decision taken by the European Union Court of Justice on the 6th of October 2015, the so-called Schrems case leading to the invalidation of the safe harbor. That is to say that EU Commission will have a continuous and evolving assessment based on an essentially equivalent protection to that guaranteed within the Union, assessing three items. First, is there in the third country or international organization targeted an effective independent data protection supervision? Are there cooperation mechanisms? Will data subjects benefit from enforceable rights and effective administrative and judicial redress rights? Let's mention that the adequacy will not be targeting only third countries, but a territory or one or more specified sectors within a third country or the international organization targeted. Let's remind also that no specific authorization will be required in the frame of adequacy decisions. And finally, that in case of inadequacy, appropriate safeguards, binding corporate rules, or derogations could still allow data transfers. Finally, let's notice that a list of adequate, no longer adequate countries will be published in the official journal of the European Union and on its website. So what's missing now is knowing what will be the Commission consultations with the third country or international organization providing with a view to remedying the situation. What will be new EU-US international agreement for framing data transfers? What is Working Party 29 upcoming guidance? What will be a new EUCG positioning in a new ruling? And finally, what will be the upcoming EDPB opinion on EU Commission adequacy decisions?